Honey, I'm also going to make you a co-host in case my internet's unstable.
Okay.
Great. We're live on Facebook.
Awesome. Thank you all so much for being here today on Saturday. Good morning, everyone. This is a meeting of the San Francisco Democratic County Central Committee. It is Saturday, February 19th, and it is 11 a.m. And this is actually not an official meeting of the full body, but it is an endorsement interview meeting. And so because of that, I'm actually going to pass this on to Chair of the Issues and Resolutions Committee, Lee-Mal Levitt. But before that, why don't we go ahead and make sure that we call the roll, because I see that it is on the agenda. So let's see.
I can do that, Chair.
Awesome. Thank you so much, Executive Director Moises Garcia.
Member Avalos.
Present.
Member Barry.
Present.
Member Baraka.
Here.
Member Campos. Member Chen. Member Dufty. He'll be late, I think. Member Galata will also be joining us late. Member Haney. Member Ibanez.
Presente.
Member Kim. Member Lacroix. Member Lee. Member Loftus. Member Lovett.
Here.
Member Mahogany.
Here.
Member Mandelman. Member Marr. Member Moliga. Member Morales. Member Raju.
Here by proxy.
Member Ronan. Member Thomas. Member Tung.
Here.
Member Williams. Member Feinstein. Member Pelosi. Member Spear. Member Kounalakis. Member Ma. Member Cohen. Member Weiner. Member Ting. There are 8 members present.
Hey,
All right.
Moises.
Yes.
Member Chen was going to reach out to you about me being her proxy today. Is that something that went through, or?
It didn't, but there's no votes today.
Okay.
It's just the
There are
interviews.
no votes today.
Yeah.
All right. Perfect.
Great. Thank you, Executive Director Garcia. We will now move to approve the meeting agenda, discussion and possible action regarding endorsement interviews for the June 7th, 2022 election. And that is the sole item on the agenda. Thank you, Member Barry. Is there a second?
Second.
All right. All in favor?
Aye. Aye.
Aye.
Any
Aye.
opposed? Any abstentions? The agenda is approved. We will now move on to item number 3, which is the endorsement interviews for the June 7th, 2022 election. For this portion, I will be passing it on to Chair of the Issues and Resolutions Committee, Vice Chair Levitt.
Good morning, everyone. Thank you for taking part of your Saturday to attend this meeting. To all the members, to the representatives from the campaigns, and also to the public. We're calling this meeting really in keeping with past practice for ballot measures. And specifically, this is the ballot measure going to the June 7th, 2022 election regarding the recall of San Francisco District Attorney Chesa Boudin. So today we are holding this meeting in order to hear from both sides. And what we'll do is have 5 minutes for each presenter, followed by 10 minutes of question and answer from members only. So keep in mind that our meetings are open to the public, but we'll actually have a process at our monthly February 23rd meeting coming up, whereby people can give public comment. And at that meeting on February 23rd, our body as a whole will take potentially an endorsement vote. So we'll speak more to the details of that. But again, this is in keeping with our policies and procedures around how we handle ballot measures, with this one being focused on the attempt to recall District Attorney Chesa Boudin. So without further ado, we are starting with the proponents of the recall. And Moises, do you have that panelist on the call?
I do. Let me bring them up. Actually, I'm not seeing Brooke Jenkins.
Is there another representative?
Yes. Lily Rapson, I'm going to promote you.
Hi there. Brooke is online.
She is. I'm not seeing her.
I know she's on, so is there another way that we can get her the link?
Is there,
Might
is
be on
there,
Facebook.
is she on the Zoom meeting, or is she or he on under a different name perhaps, because the name is not appearing in the participants?
Let me find out. 1 second.
Thank you. They were
I'm just-
here earlier, but I don't see them anymore.
Okay, let me go on mute while I try to assist.
Thank you.
While we're waiting, does anyone have any questions, or shall we talk again about this process? So for those who are just joining here and on Facebook, we are doing interviews today with both sides around the ballot measure for June 7, 2022, regarding the attempt to recall the San Francisco District Attorney Chesa Boudin. And so, you know, we've had a lot of thought in, put a lot of thought into this process, both the Issues and Resolutions Committee, which is Peter Galata, who is currently attending a Rules Committee of the California Democratic Party, and myself as the chair of that committee. Also, the Endorsements Committee in the past has really taken the lead on both candidates, of course, for our upcoming elections, as well as ballot measures. But, you know, we have now combed through our policies and procedures, as well as our bylaws, with a fine-tooth comb. And the process for ballot measures really belongs with Issues and Resolutions. Hence, we are leading that process, but also working with the Endorsements Committee. So I wanted to thank Member Ibanez, who also is our corresponding secretary, and Member Barry, both on this call. Thank you for the tremendous efforts that you have put in. I could also speak to the work of the bylaws committee, but let's save that for the February 23rd meeting. And again, the February 23rd meeting is where you'll see on the agenda that there are various items pertaining to some changes in the bylaws we have to really address recalls, since we have not had local recalls to deal with in almost 40 years until recently. Does anyone have any questions while we are waiting to promote the speaker, Brooke?
Time frame of the presenters and the question and answer time frame.
So yes, to repeat, the presenters each have 5 minutes, followed by question and answer from the members. And then that repeats. So first the proponent and then the opponent.
Vice Chair Levitt, is there a
And
time
again-
limit that's been set for questions from the members?
So we set 10 minutes for questions from the members. Now, we could, if somebody has a motion, to extend that and possibly do it after each set, that, you know, that is something that we could decide with the present the members who are present.
Vice Chair Levitt,
Okay,
may
have we had any luck?
Oh, I was going to ask the same thing, if we could get an update on the presenter.
Yeah, I'm being told that they're on the call, but I'm not seeing them in the attendee list.
I don't see them either.
Yeah, the attendee list, I think, might be, yeah, available for all, and I don't see any name. Yeah.
Hi, I know Brooke is on the call. So is there a way to send her a link right now? But she's using the one that was sent to her to register.
I see 2 Lilies. Is it possible that?
That's possible.
okay.
I can try logging. Can you try the other one that's not my name? It's possible that she's using the other one.
Yeah, just promoted. If you can also provide their email in the private chat,
Sure.
I'll also send a link quickly.
Thank you.
Great, a link was just sent.
While we are waiting, I might as well bore you with some more policies and procedures. So when we reached out to both sides, there was the discussion around whether this is an early endorsement of a ballot measure, in this case, the June 7th attempt to recall District Attorney Chase Medine. And so in our policies and procedures, and this is section 6.2, early endorsement pertains to 3 conditions. So it's a vote that's taken before the filing deadline for candidates, so that doesn't apply. The deadline for submission of a ballot measure, so this ballot measure has been submitted, so that doesn't apply. Or number 3, the calling of a special election in the case of a ballot measure submitted for vote at a special election. So since we have the date of that special election, that doesn't pertain as well. So technically, this is not an early endorsement of the ballot measure. Does anyone have questions? Oh, Brooke,
I love
you
it.
are on.
Brooke is now
Welcome.
on.
Thank you.
Let me start a timer. Great, you ready to go?
Yes.
Great, go ahead.
Oh, okay. So today I am here to ask you to do something that may be against some of your initial instincts and against what you believe many progressives may agree with. But I'm asking you to make a very serious and considerate decision to do what is best for the city of San Francisco and what is in line with what almost 1 in 5 San Francisco registered voters have indicated that they want for this city. Chesa Boudin has placed all of us at risk. Our safety is at risk, our city's economy is at risk, and the reform movement in general the title of progressive is not progressive. He is a radical. He is an extremist. He's not competent to do the job of a in line with the duties and obligations of the chief law enforcement officer of the city and county of San Francisco. He has issued blanket policies that have done away with any discretion that the district attorney should retain in making case-by-case determinations for what is best for public safety and what is more just and fair in an individual case with respect to a person charged with a crime. To do away with such discretion is not only reckless, but it's extremely dangerous. When you think of losing discretion for a district attorney, think of mandatory minimums. And those are still laws on the books with respect to federal law enforcement. And I think many of us would agree that we have issues, right? And we see problems with mandatory minimum sentences for the obvious reasons. That is the same type of problem that exists with the blanket policies that Chesa has issued in the DA's office here in San Francisco. One being the blanket policy that he will not use whatsoever gang charges or enhancements. That particular policy directive, while he touts was designed to help the Black and Latino communities, is actually doing just the opposite. I spent the last 7 years working as a prosecutor in San Francisco, working my way up from misdemeanors to general felonies where you prosecute robberies, assaults, crimes of that nature, to sexual assault, and then to homicide. I've seen in the last year and a half where the murders have occurred in San Francisco and who has committed them. And let me tell you, those murders disproportionately affect Black and Latino communities. And the victims of those crimes are primarily Black and Latino men. Many of these murders are connected to feuds between neighborhoods and gangs in San Francisco. You've heard me, I'm sure, talk about the murder of my husband's cousin, Jerome Mallory Jr., who was an innocent 18-year-old Black man walking in the Double Rock housing project when he was gunned down by 4 young men. And only because we couldn't determine, the police couldn't determine who of the 4 were the 2 shooters. It made it very difficult to charge that case in the ordinary fashion with the 187 Penal Code section. That case required the use of a gang charge in order to bring these perpetrators to justice, in order to give this family the feeling that they might get justice, that these murderers may be held accountable. And Chesa refused to do that. Jace Young, a 6-year-old boy, was killed in the Bayview the day before. And yet his father feels the same exact way, that he did not receive justice in his case. Not only did Chesa's policies not help Black victims and brown victims, but they don't help the defendants either. Troy McAllister is a prime example of that. Not only did he kill 2 innocent women who have lost their lives, but the fact that Chesa recklessly released him early is what allowed, without requiring any rehabilitation, despite his history showing and demonstrating that he had a drug addiction problem. He released him back onto the street on probation, no assistance whatsoever. And now, instead of facing a robbery charge like he was before, he's facing manslaughter. The urgency is now because people are dying. There are multiple cases where we can point to people who have been prematurely and recklessly released without any assistance for the issues that got them into jail in the first place, who have taken innocent lives because they have simply cycled back into the same behavior.
Thank you, Mr. Jenkins. Chair Lovett, sorry.
Thank you, Ms. Jenkins, for speaking for the recall Chesa Boudin side. We appreciate your taking the time. Now we have 10 minutes here for members to ask questions. And does anyone want to put their name in the stack? So we'll start with Member Tung.
Thank you, Vice Chair Lovett. It's nice to see you, Ms. Jenkins.
Yes, it's been a long time.
So I will begin by asking, and I think this is an interesting question because the body of the DCCC is currently undertaking a potential bylaws amendment, which would govern the way and the standards in which we address either taking a position on recalls, whether it's to support, oppose, or take no position at all. So the default position in a potential amendment to our bylaws includes a default to a opposition to the recall if the elected official is a Democrat. The other part of the potential language is that a recommendation to the body that the person or the official to be recalled should be supported, or that the subject of the recall the person should actually be recalled, is that the person has committed either a gross abuse of the powers of their office or criminal behavior warranting a recall. I'm wondering if you could take some time to discuss what, in your view, supports either one or both of those actions.
So I want to talk first about the second, which is criminal actions. And I believe you all should be aware of the wrongful termination lawsuit that was filed by DA investigator Jeffrey Pillay regarding a situation where he was the lieutenant assigned to working in the Independent Investigations Bureau, the unit within the DA's office that prosecutes the police and prosecutes police misconduct, where he alleges that he was told, and his other investigators were instructed by attorneys in that unit to withhold exculpatory evidence from the warrant in the People versus Kenneth Cha case. He highlights not only that he had discussions with the unit level attorneys and managing attorney, but that he took those concerns up to Chesa Boudin himself, and that his concerns not only were ignored, but that he was ultimately fired as a result of reporting these issues. One thing that people must understand is that district attorneys, unlike any other practicing attorney, are held to a higher standard of ethics. We have an obligation at all times to turn over exculpatory evidence to the defense. If we are drafting warrants of any sort, arrest or search, that we include exculpatory information in those documents, in the affidavits, so that judges make informed decisions, not just based on the perhaps arguably biased position of the prosecutor, but so that they are viewing any evidence that may shine light on the innocence of the person who may be subject to that search or that arrest. It shouldn't matter whether it is a police officer or an everyday everyday citizen, and it doesn't under the law. And so in becoming aware and being informed that this was going on and not taking steps to correct that illegal behavior, I do believe that Chase Boudin was complicit in it and therefore may have committed a crime. The second issue is that he is completely derelict of his duties at this point. He has abused the collaborative courts, which are the courts that are designed to take offenders sort of off of the track to just punitive, right? A punitive result in their case, and send them into treatment of various kinds and into programs of various kinds. There's mental health court, there's drug court, there is veterans used to determine which offenders are appropriate for those courts, and that they follow the necessary treatment measures and complete that programming to earn dismissals and reduced pleas. He is allowing that to be completely abused. He's giving people the benefit of dismissals and reductions without requiring them to fulfill the obligations of that programming, which puts them at risk of recidivism and our city at risk of their reoffense. And so for that reason, I do believe he's abusing his power.
Ms. Jenkins, if I could ask a follow-up question, what criminal behavior do you think, what crimes have been violated or what crimes have been committed by the district attorney in terms of the example that you gave or some other example?
I believe that—
I'm sorry, through the chair, there is a list. You already asked 2 questions. Like, can you wait your turn? Can we allow? I mean, it's a question. Can we allow for?
I'm sorry, Vice Chair Levitt, it's just a follow-up question.
What is the process of the questions? Because there's quite a few of us waiting to ask questions. And I feel like it's important to ensure that we all get a chance.
Let's make sure that every member has a chance. And if we do need to extend this questioning time, then we can do so by a vote.
I'd ask just for the Vice Chair's indulgence, it's a very short question that should require a short answer. And I don't have any other questions.
Leaving that information out.
I'm sorry, Ms. Jenkins. Ms. Jenkins, can we allow the chair to let us know what the process is? I apologize, but it's important for us to ensure that we have a process that all the members understand, so we all get an opportunity to answer your to ask our questions.
Absolutely. So I'm going to go according to the stack. And if you want to follow up, Member Tong, then you can also, you can ask that follow-up question. And, we are taking notes.
Okay.
We'll be sure to, pick up from where you left off.
I appreciate it. Thank you.
Mm-hmm. So I have Member Ibanez. I have Member Ibanez next to the stack.
Thank you so much. Thank you, Ms. Jenkins, for being here with us today and for taking your time to come and speak to us on this important matter. My question is, how can the DA work with educators to help keep our kids out of trouble? And how can we work together to promote restorative practices for those caught up in the criminal justice system? And what might be the repercussions for youth if the recall passes?
So I think there are ways, and DAs, especially progressive prosecutors, have to be innovative about ways to partner with the school district, right? We have to be sending DAs into the school district to discuss with our youth what lies ahead if you choose, right, to commit crime, and also serve as mentors. There should be mentorship programs so that the youth in our city see and get to know attorneys in our city that may look like them, right? That may demonstrate to them that they can become one of us. Also, it would bridge a gap between law enforcement and the criminal justice system and our youth. Because growing up as a half Black and half Latina girl in the Bay Area, I grew up in a family where police, were not trusted, and where I didn't believe the system was fair. And so it has taken time for me to get to build those relationships and to have a different view. And I think that by having prosecutors, and police form those relationships, that it can really move that ball forward. With respect to the recall and its effect on youth, right now, what I believe is happening is of detriment to our youth. What Chesa Boudin is doing by showing and conditioning them to believe that there is no consequence when you commit a crime is not helpful to them. They may not just commit a crime in San Francisco. We know there are jurisdictions just a few miles away in each direction. And if they cross south into San Mateo or go a little further south into Santa Clara, and they are conditioned to believe that if you go and steal from anywhere, that you just get let out within hours, and at most you face probation. They're gonna see something very different down the road, down 101 highway. And so we have to be helping them. And that doesn't mean you put them in juvenile hall or you put them in jail. It means we have connections and partnerships with programs that can help them receive vocational training, right? That can assign them mentors and social workers who help them get their lives on the right trajectory. And so right now, I believe he's placing not only their futures at risk, but their lives, because it is young Black and brown men that are dying, that are being shot because violence is going unresponded to.
Thank you so much.
So thank you, Moises, for doing a time check. We are almost out of time, and we'll need a motion on the floor in order to extend the discussion here. And if we do that, do we want to take another motion that when we come to the opposition of recalls, we have a comparable amount of time? So for the first motion, we have 3 more members who have questions. Do we want to extend this time? And if so, do we want to extend it by another 10 minutes?
I move that all members that have not had an opportunity to speak and ask a question be allowed that time frame.
Do we have a second for that motion?
Second.
I hear a second.
Second.
Sorry. Okay, great. So all in favor, say aye.
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 All opposed? Okay, great. So can you continue to keep time, Moises, because we do want to make sure that there is comparable time if we choose to do that. Do we have a motion in order to have comparable time for the opposition?
So moved.
Second.
Okay, a second. Great. Okay, so all in favor?
Aye.
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 Aye. Okay. Any nays? All opposed? Okay, great. So why don't we go ahead with the stack? And next we have Member Berry.
Thank you, Chair Lovett. I would also like to, in being fair, ask 3 questions myself to Ms. Jenkins. Thank you, Ms. Jenkins, for being here. I am concerned, and I want to explain to you why. First, I'd like to know if you had explored running for district attorney here in San Francisco, and if this possibly could be your motivation for this recall.
Is your question, have I ever?
Yes.
Yes, back in 2019, actually, before Chesa entered the race, I did explore it. It was a suggestion by other people. It was a very brief exploration. I didn't feel it was right for me. And so I moved on with continuing my career at the DA's office, having another child, and move forward. That is not my motivation for why I'm speaking. I think I've watched, before I left the office, there were approximately 40 plus other DAs that had walked out of the door. They had said nothing. Everybody has to make their independent choice. They went on to other, career paths. And I felt that rather than, do the same thing and quietly complain in the shadows, that people needed to understand just what was happening. It's easy to point the finger and say, well, it must be his fault. But if you've never done this job and you don't understand how things work in that office and how things work in this system, it's very hard to connect the dots. And so I made a decision that I was going to walk away, but make that explanation. I've made it clear to the, in the channels where I've spoken, that the straw that broke the camel's back was his lack of consideration or even interest in my input in a decision he made in a murder trial that I handled. And so I think had that not happened, I don't know if I would have quit at the time that I did, because I was trying to weather that storm. But the recklessness of the way that he went about making that decision signaled to me we are in a much more tumultuous situation than I even realized before that.
Okay, also you spoke about the collaborative courts.
Mhm.
What did you chair?
Member Berry?
Yes.
Yeah, sorry, to keep in line with what we were talking about, let's have everybody who hasn't asked a question do so. And so if you can put your name back into the stack.
Okay, Member Tung was allowed to
It's
ask 3 questions.
That's true.
Shall we say 3 then?
I don't
Okay.
know if I asked
Right.
3 questions. I did ask a question that had 2 parts, which was in line with the amendment to our bylaws, or potential amendment to our bylaws. So, but I'm happy to defer to Member Berry's counting of my questions, if she has other questions that she'd like to ask.
Well, I'll skip one, the collaborative court question, because what I see is they're doing really well with graduates and they want more people to participate. So I'll go on to my other question, which is about your view on gang enhancements. This body passed a resolution to remove enhancements because of the unfair sentencing it did for Black and brown people. I am a Black and brown woman born and raised in San Francisco. I was arrested before. A gang enhancement was charged on me with no validation. And I clearly see it as a way to taint the jury, to have the person who's defending their lives looked at negatively. White people in San Francisco, when they commit murder, are not given these enhancements. Therefore, people who both conduct murder depending on race can get more time than the other. I'm really sorry about your cousin, but isn't that person that did that murder facing life and murder at this time, regardless of an enhancement?
So I think you have to first understand there's a difference between a charge and an enhancement. So there are gang enhancements, but there are also gang charges. When I'm speaking of the Mallory case, I am speaking specifically of a gang charge, not an enhancement. In this particular case, what would have been necessary was a gang conspiracy charge, which would have carried with it the same penalty as a murder case, but which doesn't require proof of the specific shooter, because what the law has realized, right, what it realized when it created that charge was that oftentimes gang members work in concert, right, and that it's very difficult at times to be able to determine who is doing what. And so in that particular case, I wasn't asking for an enhancement. Right. If you're charged with 187, you're facing 25 to life. What I was asking, what I'm saying Chaser refused to use was a charge, which would have allowed us to prove that these 4 individuals were participants equally in this murder. When you charge someone with 187, you are required to prove that they actually committed the murder. And if you cannot prove that they were the trigger man, then it's highly unlikely that a jury is going to convict. And so it doesn't charge and what the ultimate outcome of the case is. It doesn't matter if you mischarge a case. That shouldn't be what matters. It should be whether you charged it correctly so that we get justice at the end, so that the outcome is fair at the end. And so
isn't that a racist system when white people are not charged with that?
Well, actually, that's not true, because I'm aware of particularly Hell's Angels cases.
Sorry, I don't think we should do follow-up questions. I'm sorry. Sorry, Ms. Berry.
So I think we should move on because there are a few more. And Member Berry, if you'd like to put your name in the stack at the end, we will consider, because technically we voted on having people who had hand asked questions to be able to all do so. So I have next Treasurer Morales.
Thank you. Thank you, everybody, for being here today. And happy Lunar New Year again. So I'm Treasurer Carolina Morales. I am an immigrant Latina. I've been living here for 20 years since I was 17 years old. And I've had friends and loved ones charged with gang enhancements and gang charges, and even added into lists about being gang members without them being so. And I have a couple of questions related to both just charges and being in kind of like race in this efforts, right? Both the efforts of DA Boudin and the efforts of the recall. So so the question is two-part. So the first part is kind of like a more global question regarding race, and it's during the District 11 Democratic Club meeting a few months ago. There was a representative from your campaign that joined the meeting and made statements regarding the efforts by DA Boudin being racist efforts against whites, and then part of my comments were used by whether the campaign or somebody who claims to not be part of the campaign to smear me on the internet for responding to this. And as a fellow woman of color, like both the efforts, you know, to smear me and the also comment of racism against whites by a representative from your campaign who is white during the District 11 Democratic Club meeting feel like a representation of the misunderstanding of what are we talking about here with criminal justice reform and the mass incarceration problem in this country that has impacted mostly Black and Latinx people. And in San Francisco, that is the case. We have in our jails a majority and disproportionate majority of Black and Latinx people in our jails. So I just wonder, you know, what do you think about kind of like how race plays a part in this efforts and in criminal justice reform in particular, which is the main platform of DA Boudin, and connected to that and charges both around gang enhancements or robberies, or, you know, what charges that might lead somebody to be in alternative courts or not. Can you please explain to us what is the role of judges, DAs, and public defenders in the system? Because I do believe, and I don't know if I'm misunderstanding, I am a social worker, I am not a lawyer, but I believe it is judges who make the final decision on somebody being released or not from jail. And also in alternative courts, judges ultimately have the power to say that somebody is or not fulfilling their treatment plans as mandated by the alternative court. So I'd love to know your responses on both. Thank you.
So let me start at the end. The system requires advocates on both sides. It doesn't mean it that again can't work cohesively sometimes to come up with, you know, the best ways to resolve cases or to manage cases. But in order for this system to function, you have to have a voice on both sides. The public defenders are tasked solely with advocating for the interest of of ethics. They cannot do anything to present the interests of the people.
Sorry, through the chair, Ms. Brooks, we're having trouble with your connection. Perhaps if you turned off your video, we would be able to hear you better.
Okay.
Apologies.
Is that better?
Yes, it is.
Okay. Yes, at times, the judge is responsible for whether or not a person is released, particularly at arraignment. But if the DA's office comes in and says, we concede to this person's release, or what's also common is we won't take a position, judge, we just defer to you and whatever the public defender is arguing, then there is no voice for the people. There's only a voice from the public defender who's going to take a very, very strong position, right, to advocate for the release of their client. The only information that the judge will receive is from the person tasked with representing that client. And so even if it's up to the judge, the DA's office has to take a position and express the basis of that position to the judge. That doesn't mean every single time we should be asking for somebody to be held in custody. Of course not. But there are times when you need to, particularly with violent people, with chronic offenders who are, cycling back in and out, picking up multiple cases. And so they have to take a position and express what that position is. And when that's not happening, or when we are coming in and taking a position that is to simply concede to release, then you can't point the finger at the judge and say, well, it was the judge's decision. I was raised by a Black single mother. My father is from El Salvador. He's not a citizen of this country. He doesn't live here. I've been uniquely positioned in the DA's office to not only watch my cousin be walked in handcuffs and in orange facing charges in San Francisco, other people I know from where I'm from come in orange being charged. And I've also, as I've just discussed, been on the other side watching my husband's family suffer as victims do. And so I'm married to a Black man. I'm raising 2 Black children. There is no one you're going to talk to that doesn't see race more in this system, and the significance of race with respect to criminal justice reform. I completely understand the need for it, but there is a way to do it. And what I've said repeatedly is that the way Chesa is going about it is wrong. Ways to go about reform so that you don't simply disrupt the ecosystem in a city that leaves people in danger. Reform and public safety tools that he has to ensure that reform is done. I'm sorry.
Apologies, Ms. Jenkins, but the audio is still cutting out at various times, and
I am in a hotel live, so okay, I'm sorry. I'm in a hotel on a family trip, and so I'm sort of at the liberty of the hotel's Wi-Fi system. I apologize.
Understood. Do you have some audio call-in options in the invite that you got? Perhaps when the next person asks their question, we can try that approach on your cell phone.
Okay. I don't know if you want to send it in the.
I think. Moises, could you go ahead and do that, please?
You can send it in the chat.
It seems like you're yeah.
There should be an option to dial in your panelist.
Oh. Okay.
And thank you all for bearing with us. You'd think that after 2 years on Zoom, we've totally mastered it, but I can attest to the fact that Zoom still continues to mystify us. So we appreciate your patience on a Saturday morning, especially if you're traveling and you're on vacation and you're on this call.
I'm calling in now.
Your meeting ID followed by pound.
So bear with us, and I believe there's a *6 in order to unmute. And there should be some prompts. So in terms of stack, I believe that everybody who's asked a question for the first time has done so. And I think we are coming back to Member Tung, and then followed by
Chair, Member Avalos
I
hasn't
thought
had
it
a
was
chance.
Member Ibanez?
Member Ibanez was before.
Okay,
Yeah.
Member Avalos has not had a chance, so I will allow.
he
him.
hasn't spoken yet, so. Okay. So, and then it looks like he's taking Member Avalos. is
How about I
taking
just do Zoom from my phone? That
off
might
the
actually
stack.
work better.
Yes, we can
That's
hear you
good.
much better now.
Sure thing.
Thank you so
Yes.
much.
Okay. Thank you so much. Yes.
No problem. So
everyone for
I'm
your
going to leave
patience.
momentarily.
Should we? Okay, great. Shall we have Member Ibanez with her question? And I'm sorry, it's actually Member Tung. Member Tung, do you want to restate the question you wanted to ask? And then
Sure.
when Brooke comes back on, you don't mind, then just
Sure.
summarizing through.
Sure. The question actually was a clarification or follow-up with respect to what she had said about the DA having committed criminal behavior. I wanted a little bit more specificity from her on that issue.
Welcome
Okay.
back,
Actually,
Brooke.
thank you. This is my iPad, which has cellular. The camera's angle is a little off, but I'll make it work.
Great, we're on again. Okay, so Member Tung, would you like to restate your question? It was a lot
Sure.
from previous.
So Ms. Jenkins, one of my initial question was with respect to the new parameters that we may be considering for the bylaws. And you indicated that you believe that the DA may have committed criminal behavior with respect to some of the civil lawsuit that had been filed by a former investigator in the Independent Investigations Bureau. And I was wondering if you could point to specific penal code sections or what specifically the criminal behavior you believe has been committed.
Well, I'm not at this moment prepared to cite penal code sections. I mean, obviously, if he wrongfully terminated an employee who was ethically obligated to report.
Is this something that has been already being charged with, and there has been a court determining that he's guilty of such charges? This is just to be, for the record, your own opinion, not necessarily gone through the criminal justice system, because I think I want to stick to the facts and not opinions.
Well, I think Ms. Jenkins, I'm asking Ms. Jenkins to render an opinion because she's stated, or to support her statement, that there has been criminal behavior or a crime has been committed, since that is the framework with which we're looking at in terms of the future endorsement. So, Ms. Member Ibanez.
I'm sorry, but I want to make sure that, because let's look at the facts. Facts are important. If it's an opinion, it's an opinion. And I'm sorry, but I want to be able to, I've heard a lot of opinions already from Ms. Jenkins, which it's her right to say that, but at this matter, when there is charges being charged, I want to make sure that it is coming from the court systems and not from someone giving her opinion of the matter. And I would say that's also my opinion.
Right. But, I appreciate that. And I think it's very clear that this is going to be Ms. Jenkins opining here in this particular instance. The suggested changes to the bylaw do not require a criminal conviction or a criminal charge having been filed, but that the person who is the subject of the recall has committed criminal behavior warranting a recall. So that's the point of clarification that I'm asking for Ms. Jenkins. I think it's abundantly clear that this is her opinion only and not any anything that has been filed. There have been no criminal charges filed against DA Boudin in this regard. So I'm just asking her for clarification on what the criminal behavior is.
So I don't know if I'm at liberty to speak yet. I want to make sure I don't do anything.
Yes, you are.
Okay, so this particular lawsuit, of course, has to play out in court. It's a civil lawsuit. It's not a criminal matter. The Department of Justice and or the State Attorney General's office will determine what they want to do. And I, of course, don't plan on weighing in on that. The suppression, all I can say is this: the suppression of exculpatory evidence is a violation of federal and state law. And again, that is to protect defendants. Regardless of what your stature is in society, regardless of whether you're a police officer or, you know, a homeless 20-year-old, it doesn't matter who you are afforded the right to have exculpatory evidence in your case be handled correctly. And so that's the issue that I see in this case, whether or not, right, it ultimately bears out to be a crime, I don't know. I do not have all of the facts. I only have what's a public record.
Thank you, Vice Chair.
Okay, do we have somebody else in the stack? I am looking through the chat here.
I removed my name from the stack because I just didn't
Yes,
really
you did.
feel like asking questions to get opinions that are based on, you know, conjecture and hearsay is adequate for us to make a decision on. And a lot of this ability to actually have a recall is backed by people who are anti-reform and are really strongly trying to put in place a system that overall is oppressive, that DA Boudin has been trying to reform so that we could have a broader sense of justice. So I'd like to go on to our next, hear from DA Boudin.
I do actually see that member Barry has put herself in the stack. Shall we do one more question and then conclude?
Thank you.
Okay, member Barry, and you're the last.
Okay, thank you, Ms. Jenkins. You, in your opening, you emphasized on this gang charge subject, and I brought up to your attention that white people are not charged with this additional charge when they murder people. And then you responded with the Hells Angels. I see now that the president of the Hells Angels is in pretrial, and he is not being charged with gang enhancement. So can you explain that?
I mean, you've given me information in a very small vacuum. I have no idea anything about that case. So I can't speak in a vacuum without facts as to why that would be the case. I used Hells Angels as an example because I am aware of in the past few years, there being a gang case charged against Hells Angels for what I believe was an assault. But I'm not in a position to weigh in on what particular enhancement is or is not charged in a case where I don't know the facts. I know the facts of the Jerome Mallory case, which is why I've articulated an opinion about it. So I think what's being missed is that this isn't about saying, oh, let's just use gang enhancements whenever, you know, for any and every case. The issue is that a DA needs to be thoughtful about it. You can't issue a blanket policy that doesn't afford you the ability to give a family justice when there is a charge available under the law to give them justice that's appropriate in the case. When you take a blanket policy that's sweeping, you don't afford yourself that ability. The DA can be very, very thoughtful about when gang charges are used. He or she has that ability. And so that's the issue here.
I
It's not
understand,
using
just
that
black and
discretion.
brown people gangs. Okay, I understand.
No,
Thank you.
no, this is a young black man that died. And so at the end of the day, there needs to be a care for his family. What about his family?
So I'm gonna, Chair, I heard enough. I'm sorry. I think Ms. Jenkins, with all due respect, again, I am very interested in facts and not opinions, and I move to close this debate.
Do we have a second?
Second,
Third,
Okay. So all in favor, say aye.
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 Okay. Any opposed? Okay, so Moises, could you give us a time check on that? Because we did vote to allow equal amount of time for the side that's opposing the recall.
Yes, the total time for Q&A for the the proponents was 38 minutes, 37 minutes.
Okay,
Through the
37 minutes. So to keep, yes, Treasurer Morales. Mhm.
May I just ask a clarifying question for procedure? So that are we going to be allowed to make follow-up questions? I mean, I think no, but question one. Question two, are we allowed to make statements that don't lead to questions? And then three, can we make sure that if we are speaking out of turn, can we ask through the chair? So those are my three questions. Thank you.
Right, so good questions. So to the first question, I think we should start and state if we have like a two-part related question. And that way we're not going to continue having a follow-up question when we should allow others who haven't spoken to, to take their time. They can always come back and add themselves to the stack later. Can you repeat the other two questions? Your second question was?
That if we're allowed to add or make comments that are not leading up to a question.
Yes, we are. And, and within reason as well. So this is not the space for us to just continue to state our own opinions, right? This is a dialogue with the people from the campaigns. And then the third question was with regard to.
Oh, just if we're speaking, like if we're not on the stack and speaking out of turn, if we can ask you first, like through the chair, if we can address the work.
Yeah, technically, please say through the chair as we are keeping to Robert's rules of order. Thank you very much.
Through the chair, also technically, maybe we shouldn't interrupt.
So we proceed with.
Yes, I'm promoting.
Right, and it's very. Welcome, DA Budin.
Thank you very much, Vice Chair Levitt. Good to be here. Members of the committee, appreciate all of you taking time on a Saturday to go through this important endorsement process.
I'm starting your time, 5 minutes now.
Great, thank you very much. Many of you, as did the majority of voters in San Francisco, support my election in 2019 above other candidates who ran for that office in a free and fair and vigorously contested election at core for three main reasons. First of all, a commitment to find ways to build and promote public safety without simply relying on jails and mass incarceration as a solution. Second, because of a commitment to invest more resources and more effort in supporting survivors of crime, victims of crime, those harmed when people break the law. And third, because of a promise that I would take steps to hold those in power accountable in ways that are equal with those who are traditionally prosecuted and sent to jails and prisons. In other words, that we would enforce the law equally. Now, I want to just reflect back on the barely 2 years that I've had in office, 2 years defined in so many ways by a COVID pandemic, an economic crisis, and drastic changes to how all of us live our lives, and what we've been able to achieve in fulfilling those three core promises, despite the very real challenges that we've faced as a city and as an office. First of all, when it comes to reducing our reliance on jails and prisons, we've seen a dramatic increase under my tenure of reliance on collaborative courts and treatment courts, expanding mental health diversion, expanding behavioral health court, and other similar courts. We've also seen, at the request of the jail medical director in the heart of the COVID pandemic, a significant reduction in the jail population, even as overall crime rates have fallen. We ended the use of cash bail so that people are being incarcerated based on their risk, not based on their wealth. And at core, I think, to many of our values, given the history of the positions this committee has taken, we've reduced juvenile incarceration by more than 2/3, because we know in San Francisco that neither on our watch here nor at the border do children belong in cages. We also have taken critical steps to invest savings in victim services. We've increased the number of Chinese-speaking victim advocates by nearly 500% since I took office. We've also increased the overall size of our victim services division by nearly 1/3. Just last year, we fought for and successfully secured funding through the Board of Supervisors add-back process for 10 new victim advocate positions, including, for the first time in the history of San Francisco, advocates who are focused exclusively on victims of property crime, something we know to be a major issue when it comes to crime in San Francisco. And during the heart of the pandemic, when survivors of domestic violence were forced to shelter in place with their abusers, we stepped up, found partnerships to create short, medium, and long-term housing for those who otherwise would have had no choice but to go onto the streets or stay with abusers. I could and I'd like to talk a lot more about the work we've done to support victims. I want to give you one last example because I know my time is short. We recognized in a policy, it's the first of its kind in the nation that we're aware of, that even those harmed by police violence, whether criminal charges are filed or not, are worthy of victim services, are worthy of supports and resources. We implemented a policy that guarantees no mother whose son is shot and killed by San Francisco Police Department officers will be required to rely on a GoFundMe page to cover funeral and burial expenses. That policy, which we implemented, treating all victims of violence equally, regardless of who causes the harm, is now a model for a state law in Sacramento. And it's not just about supporting victims. It's also about ensuring accountability for everybody who commits crime. And look, I'm proud of the more than 10,000 new cases my office has filed since I took office. I'm proud of the murder indictment that I personally secured in front of a grand jury. But I'm also proud of the fact that we don't only use the power of our office to prosecute poor people of color. We're also filing, and we're now in the first ever trial, at least in modern history, where a San Francisco Police Department officer is facing charges for his use alleged of excessive force. We're also doing things that are at the core of public safety and equal enforcement of the law, like suing the manufacturers of ghost guns to get their guns off the street so they stop profiting from the pain and suffering that their weapons are causing in our communities. We're also promoting laws that will prevent crime and prevent victimization. I was proud to co-sponsor a state law that would extend the age for foster care youth before they age out of support from the state to make sure that they have transition as they age into adulthood. And similarly, we're right now at the forefront of a national movement to ensure that victims and survivors of sexual assault are not having their own DNA used against them. And I'll stop there. I see my time has ended.
Thank you, Dave Budin. So since we had a vote in order to have equal amount of time for both sides, then we will have 37 minutes for questions from the members. And let's start with Member Berry.
Thank you, Chair. Thank you so much, Mr. Budin, for being here. I feel bad because I know your job is at a scope that we can't even imagine how busy you are. I want to hear, the media often harps on the same misinformation. And I was going through a lot of your accomplishments. And one thing that we haven't really heard about, and I hope you can expand on, is your memorandum of understanding with USF Law School Immigration Clinic. There's a diversion program you guys are working on for unaccompanied children who are the victims of human trafficking. Can you share that good news of what you did with that?
Thank you for the question, Barry, Member Barry, and I do appreciate all of you taking time on a Saturday. I know many of us, like me, have young children at home. I know that's something we're all balancing, so I appreciate that. The program you mentioned is a program we created because of a recognition that many of the young people we were seeing brought to our juvenile court for possible charging and prosecution were in fact themselves victims of human trafficking. This is not something that you hear about a whole lot in the media, partly because of the appropriate protections that our law requires for cases involving minors. They're treated very differently. They're not open to the public except for in exceptional circumstances. But what our staff saw over the course of years was that many of the young people being arrested were themselves victims of trafficking, of sexual abuse, of other kinds of abuse. Many of them were undocumented and had nobody in their life, no adult in their life in this country to depend on for support or guidance. And so we created this partnership you mentioned, Member Barry, with USF Law School's clinic to ensure that these young people, while we're holding them accountable for what they were arrested for, are also getting the supports, the counsel they need, and potentially the services, so that when we're done with our case, instead of being dumped back on the streets with a juvenile adjudication on their record, instead, hopefully they're on a path to being able to obtain lawful employment, housing, and all of the kinds of guidance that any of us would want for our children if they found themselves in another country without their parents.
Thank you for keeping your promises.
Thank you, Member Barry.
Okay, so next we have DCCC Chair Mahogany.
Thank you, Chair Lovett. Good afternoon now, the District Attorney Boutine. I would like to ask a question in regards to crime statistics. Your opponents or the people on the other side have mentioned that San Franciscans are feeling less safe, and that crime is on the rise, and that your policies have made San Francisco a less safe place to live. I'm wondering if you could speak to violent crime rates in San Francisco, how they have changed over the last few years, and also how San Francisco compares to other major cities.
Thank you, Chair Mahogany. I want to first preface my answer, and I appreciate the digging into data. I know there was a lot of conversation previously about opinion. I think data is really important when we make policy. And I also want to just point out that the things that drive short-term crime rates are way outside the power of any individual district attorney. And I wish that weren't true, right? But, and this gets to the second part of your question, Chair Mahogany, but if you compare San Francisco crime rates with jurisdictions that have very different policies, jurisdictions with very traditional Republican district attorneys, like say Sacramento, for example, right? Or even Alameda County or other counties around the country, what you see is that often crime trends in one jurisdiction and another move in parallel, even when there's very different policies by the DA. And that makes sense if you think about the big picture things that drive crime, right? Access to guns, for example. That's been a major driver of violent crime and homicides across the United States over the last 4 years as the Trump administration promoted and encouraged gun ownership and relaxed regulations that made it possible for people to get guns on the internet with no serial numbers. Similarly, the economic crisis that came along with the COVID pandemic led to dramatic changes in crime trends that are way beyond the power or scope of any individual district attorney or police chief or even mayor to fully solve. Now, with all that said, Chair, you asked a very important question about San Francisco's data. So I want to share with you what the data says, and I'm going to put a couple of links into the chat. If members are interested, you can look at the data in more detail than I'll have time to explain. This is a link that provides high-level historic data comparing violent crime rates and property crime rates in San Francisco over time. And what you can see is that actually crime rates are lower than they were before I took office overall. Certain categories have gone up. Here's a more nuanced look at the individual categories that you can get from the San Francisco Police Department dashboard itself. And this dashboard allows you to toggle back and forth between different years and compare them. At a high level, Chair Mahogany, there are certain categories of crime that are far higher today than they were in 2018 or 2019. And those include certain categories of burglary, it includes certain categories of gun violence. There are other categories that are far lower. Overall, my first year in office, auto burglaries fell by about 40%. Overall, robberies fell by roughly 20%, assaults fell by roughly 15%. And overall crime reported to SFPD fell by about 20%. Now, I know one of the things that's always important when we talk about data is to know what it covers and what it doesn't cover. And those statistics are taken straight from the San Francisco Police Department based on crime that gets reported to them. And we read an article, many of us, I read an article this morning that Heather Knight wrote in the Chronicle. It was a follow-up to last week's piece that reports widespread frustration with residents of San Francisco who allege that they asked police for help and police refused to take action. We also hear that people don't report crimes. There's lots of reasons why people choose not to report crime. If they don't report crime, then it's not captured in these statistics. We don't have any particular evidence that crime reporting is less common today than it was in 2018 or 2019. And so what statisticians do is they assume a relatively consistent level of underreporting, and then they compare the numbers based on what does get reported. And if you look at those numbers that do get reported, overall crime is down. It's also true that from 2020 to 2021, crime went up in most categories. And it went up in part because the city was reopening, there were more tourists, there were more people walking around and interacting with each other. But most categories did not go up back to where they had been in 2019. In other words, rapes are lower, robberies are lower, assaults are lower, overall property crime is lower today than it was in 2019. That does not give me any cause to celebrate. We have far too many crimes. We have far too many crimes that go unsolved, or where the tools we have as prosecutors are inadequate to intervene in ways that make victims whole or that change people's lives. And so while we need to look at data and be guided by data, it's critical for me and for my office to continue doing everything in our power to prevent crime before it occurs. That's why we filed multiple lawsuits and amicus briefs targeting gun manufacturers, because we know that getting guns out of the hands of people who use them to commit crimes is far more effective than simply waiting for a crime to be committed, hoping the police make an arrest and that we have the evidence we need to send somebody to prison. So we're doing everything we can legislatively, policy-wise, in terms of grants and partnerships, and in terms of early intervention with people who we see red flags for, to prevent crimes from occurring. That's the way in the long term we can continue to drive those numbers down. Happy to answer more questions about data, and I'll put one more link in the chat for folks who want to compare crime rates with charging rates historically or during my administration.
So Chair Mahogany had that.
Oh, I'm sorry. I see the second part of the question in the chat, Chair Mahogany. I'm sorry. Thank you, Vice Chair Lovett. It depends on which cities you look at. What I can say is that San Francisco's homicide rate, which is a category that tragically has gone up over the last 2 years from a 56-year low in 2019, has gone up far less than many cities, including Oakland across the bay, where homicide rates have roughly doubled from one year to the next. And so certainly compared to the level of gun violence and homicides we're seeing in Oakland, we're doing far better. When it comes to other big cities, similarly, if you look across the state of California, overall, those counties that are governed by red or Republican district attorneys have seen crime go up far more in the last 2 years than those that are governed by Democrat or blue district attorneys. So obviously it depends on which city and which particular crime rate, but overall San Francisco continues to be one of the safest cities in the country, with the caveat that property crime rates here continue to be higher than average. And for point of comparison, we hit a peak for things like auto burglaries and property crime in 2017. And it's pretty steadily dropped down from there. So we are moving in the right direction. But obviously it's not linear. And obviously these high level data conversations mean nothing if you're one of the victims who has suffered in the last year. The data and the statistics and the trends don't mean anything. And that's why I'm so proud of the expansion of our victim services work and our team, including 8 new hires in the last 6 months who are bilingual, because we know that language access is a critical issue. Now I know I'm straying a little bit away from your conversation, your question, Chair, about data. So let me stop and make space for other questions.
Thank you, DA Badin. So next we have Member Ibanez, I believe.
Yes, thank you so much, Chair Lovett. District Attorney Budin, thank you so much for being here with us and sharing your afternoon with us in this important meeting. So my question is about restorative justice in our courtroom, specifically for Black and Brown and poor people. And obviously, I come with perspective in terms of education. And it's the same question I asked the proponents of the recall. How can the DA work with educators to help keep our kids out of trouble? And how can we work together to promote practices for those caught up in the criminal justice system? And the third question, if this recall is to go forward, what impact will your stances have on the future of decriminalization and reentry?
I'm going to try to take notes, Member Ibanez, to make sure I remember all 3 questions that are related. If I forget
I'll write
any,
it on chat.
oh, thank you, I appreciate that. We have in our office a program that actually predates my tenure called Make It Right. And when I took office, the Make It Right program, which is a restorative justice program aimed at youth, at young people, children, adolescents who are accused of criminal behavior. And the idea is to give victims in those cases the opportunity to participate in a restorative justice process. When I took office, that was in a beta testing phase where they were doing basically blind A/B testing. And without getting into all the details, what that basically means is that 50% of the youth who were eligible for this program were prosecuted in the traditional way. And the other 50%, someone would reach out to a victim and ask what their preference was. We had such overwhelming success with that program. And the data, by the time I took office early in my administration, was so clear and so strong that I made the decision to stop the testing phase and move into a full-blown policy. What we saw is that we had a massive increase in victim satisfaction when victims chose to go through this process. And critically, from a public safety standpoint, we saw a massive decrease in recidivism or rearrests for those young people who had gone through this program. And for folks who want more information and data, I'm going to put a link in the chat to a description of this program and some of the data. It's been profiled as recently as I think last month on KQED because of the really amazing successes it's had in saving lives and preventing future crime and reducing youth incarceration. To your second question, Member Ibanez, about how we can work with educators, I think this is a critical issue. I mean, we know that there are public safety issues that occur in schools, and we need to make sure that teachers and educators and school administrators feel comfortable working with our office, knowing that we will hold folks accountable in a way that doesn't destroy their lives. And sadly, but my brother's a 6th grade public school teacher. He's been in the same Bay Area public school classroom for 17 years. And he's seen some of the kids that were his students end up in prison for nonviolent offenses. And when teachers who invest, when educators invest so much energy and heart and soul, as my brother and so many members of the San Francisco Unified School District do every single day, they don't want to cooperate with a system that's set up to destroy the lives of their students. They want to cooperate with a system that recognizes we need consequences and accountability, and that young people are going to always make mistakes, and those mistakes shouldn't define the rest of their lives. That's what this Make It Right program does. That's the approach that my juvenile division takes. And that is, I think, something that's really at stake in this recall. There is absolutely no guarantee. In fact, I think we can be confident that if I were recalled, whoever were to become DA would go back to prosecuting juveniles as adults, ignoring massive and undisputed evidence about brain development and about the reality of prefrontal cortex development in young adults and the kind of decision-making that leads to. We know the science shows us that young people make mistakes and that they can change. And we look around the country and we see people who were given a second chance in leadership positions in key corporations, in social sciences and academia. We have children of promise, and we're not going to destroy that promise in a juvenile jail cell.
Thank you so much.
Okay, so next in the stack, we have Treasurer.
I think me. Yeah. Sorry, it's like I think you're cutting in and out too, Vice Chair.
Sorry.
Okay. So I have a few questions. I'm trying to look for ways to bring them together. Thank you again, everybody, for being here. District Attorney Boudin. So these two questions are connected to me in a topic of misinformation. This is very important for me to bring up because in the 20 years that I have been in San Francisco, I have witnessed time and time again people involved in politics using spinning information to basically convey what should be actually called lies or half-truths, okay? So I want us to make sure that us as members of the Democratic Party and also all of our Democrats and voters who are watching are very clear about how some of the parts of the system work. So one is a question around judges' discretion, which is a question I also asked the representative of the recall campaign. And I think she really did not answer the question. She started speaking about advocates and being an advocate as a public defender and an advocate as a DA. My question was not about advocates. My question was about what is the judge's discretion in terms of releasing or keeping behind bars any defendant or a person accused of a crime, and also question. And I also named, and in terms of alternative courts, which was mentioned by this person, in terms of treatment plans, what is the judge's discretion when somebody seems to be or not completing their treatment, right? So I want to hear, please, the facts. I don't want opinion around judge's discretion. And then the other question related to accurate information is there was a lot of talk about a particular case, which I want to name. It's a case about police brutality and a very brutal beating of somebody by police here in San Francisco. And there was a commentary about exculpatory evidence and trying to use that to claim that you are committing a crime. And that somehow connects to our new processes in this, in recalls, right? So what I want to hear from that particular set of comments is, has the court ruled on that exculpatory evidence? And can you talk a little bit about that? So again, judge's discretion, exculpatory evidence. And then I want to make a comment, given that I did ask a question. I try to be very fair. I did ask a question to the vice chair if we could make comments that were not leading to questions. And here is my comment. I want to make a comment to the public connected to some of what DA Boudin mentioned regarding critiques that are being made about police arrests and police behavior, especially during the pandemic. that I am very appalled at the fact that the police department has used DNA that has been extracted from a rape victim through a rape kit, which let me just remind or share with everybody as a survivor, rape kits are very, can feel almost as violating as rape itself because of the way that medical personnel needs to extract this DNA. And so the fact that that was used to charge this victim of rape with a crime really enrages me. I am beyond appalled at this. And so I just wanted to make that comment because I think it needs to be said. Thank you.
Thank you, Member Morales. I took notes, so I'll try to keep track of all three questions you asked. And let me just first say, I share your outrage. It was shocking, it's horrifying. And the fact that we don't even have clear answers today about how this happened or what policies are going to be changed is really frustrating. The first question you asked was the factual process, a description of the process for how the release decisions are made in cases. So I want to be very precise. It's by judges, yes. I understand that the criminal legal system is complicated, especially for non-lawyers. I know all of you have a lot of experience, so I'm going to be very precise and detailed here, and I'm certainly happy to take follow-up questions. The way that 99% of criminal cases are initiated is that police in San Francisco make an arrest. And when they make an arrest, they take the person they've arrested, in felony cases, certainly to jail. And when they're taken to jail, the police officers hand the person over to the sheriff who runs the jail. And at that stage, the police officers usually go back to the station to begin writing their report. While they're writing their report, before my office has even been notified that they've been arrested, that the person is sitting in jail, a judge begins a process in dialogue with pretrial diversion about whether or not this person should stay in jail or be released, and if released, what level of supervision should be imposed. It's a process that predates my tenure. It's a risk assessment algorithm that the courts chose to adopt back in 2016, April of 2016, and that has been in place with some modifications ever since then. What happens in the vast majority of cases, particularly nonviolent cases like drug dealing or other property crimes, what we see is that folks, if they don't have some other warrant for their arrest, if they're simply arrested, say, for selling drugs, they will be released at the discretion of a judge before my office has even received a copy of the police report. Now, I want to be clear, I'm not saying this as a criticism of judges. They're following a constitutional mandate and process to review each arrest for probable cause and to balance the presumption of innocence and other rights of those arrested and accused of crimes against public safety and other considerations. That's the job judges have. It is not the job of my office. And it's really important for people to understand at this stage that I'm describing, there is no advocacy by either side. This is not something that happens in open court. It's not something where my lawyers get to stand up and argue and the public defender has been appointed. This is all before we've, in many cases, even received a copy of the police report. In other words, we have 48 hours from the time someone's booked into jail to decide whether or not we're going to charge them. And the vast majority of nonviolent offenders in San Francisco will be released during that 48-hour period prior to us making a decision about whether we have enough evidence to charge. Now, once we decide, in those cases we decide to charge, and we do charge the majority, we charge cases at roughly 10 to 15 times, depending on the category, higher rates than police are making arrests. When we do charge, we have what we call an arraignment. That is the first court appearance. That's the first time that a defendant, person accused of a crime, is formally appointed a lawyer, informed of what the charges or allegations against them are. And it's the first time that my office has an opportunity to make any kind of an argument in front of a judge in open court. At that first court appearance, we make recommendations to the court about what we think should happen. Should they be detained pre-trial? Should they be released on home detention with GPS? Should they be released with anger management or drug counseling? A wide array of options. And that decision is made not by me personally, but by a team of lawyers who on average have more than 20 years experience in the office. in our general felonies and our misdemeanors teams. The lawyers who are charging those cases make the decision at the time of charging, and the assistant district attorney handling the case goes to court and makes their argument for what they think should happen. After arguments are made by both sides, to your question, Member Morales, the decision is always made by the judge. It's made by the judge. It's the judge's power. There are many, many cases where we think someone should be detained in custody, where we make that argument, where we make it in writing, and where judges disagree with us and let people out. And in some instances, those decisions result in future crime. It's tragic, it's frustrating, it's how the system is designed, checks and balances. It is not up to me or up to my assistant district attorneys to simply dictate who stays in jail or who doesn't. We advocate, and we hope judges listen to us and follow our arguments. Sometimes they do, sometimes they don't. It's a really similar process, Member Morales, with the alternative courts that you asked about in the next part of this question. In the alternative courts, let's say drug court, for example, a court where I spent time practicing, the treatment itself is overseen by healthcare professionals. Many of them are either in nonprofits or on staff at the Department of Public Health. And what they do is they do assessments using their work as social workers or healthcare professionals to assess the needs of the person in this behavioral health court or in this drug court or in this community justice court. And then they make connections. They oversee drug treatment or drug testing. They oversee a path to employment or to housing. And they make regular reports to the judge. And the defense lawyer and the prosecutor see those reports and they discuss the progress that's being made. And they make, as in the example I just gave you a moment ago about that first court appearance, they make recommendations about what should happen. If someone slips up and relapses, should they be thrown out of the court and go back over to normal criminal prosecution, or should they be given another chance, perhaps with increased supervision or residential treatment instead of outpatient? Those are the decisions that are being made every day in our collaborative courts, and they're being made at the recommendation of healthcare professionals and social workers and case managers, with arguments being made by both lawyers and the ultimate decision being made by the judge. That's how it works in a courtroom. The judge is the one who makes the final decision. Judges can refuse to do what we ask them to do in virtually all circumstances where there's a decision being made in a pending active case. And finally, you mentioned, Member Morales, allegations of suppression of evidence or withholding of evidence. And I want to be very clear about the misinformation and the spin that has confused, I think quite intentionally confused this issue. The allegation is that the office did not provide some information to the police department. The police department does not have a constitutional right to receive evidence of an ongoing independent investigation. The reason that the team that investigates police use of force is called the Independent Investigation Bureau is because it's independent of the police department. And it was designed precisely to ensure that the police department would not have access day by day, blow by blow, to the ongoings of the investigation until the case is closed. This case is not closed. It's in trial. The judge who made that point in the record and made the point that the question before her, the critical question in any criminal case, is were the due process rights of the defendant, of the person accused, who does have constitutional rights to exculpatory evidence, to information about their case, were those rights violated? Was evidence withheld from the person accused? And the judge ruled clearly that that had not happened here, that no evidence was withheld, that the defense had access to all the evidence they needed. And that's why we're in trial. If the judge had found that something had been withheld, the remedy likely would have been dismissal of the case. That's not what happened here. So the facts are really important. And as you point out in your comment, Member Morales, there is a lot of spin and a lot of dishonesty in an attempt to confuse people as to what's really happening. I understand that. Sometimes defense lawyers like to muddy the water to create doubt, but it is very frustrating to see it happen in the press in a historic case where it seems clear the design is to undermine the fair process that has to occur inside the courtroom.
Thank you, DA Badin. So we have a member Tung in stack, and I am mindful that we have 7 minutes left for our question and answer period. So member Tung, take it away.
Thank you, Vice Chair Levitt. Good afternoon, Mr. Boudin. Nice to see you. I do sympathize with you about the prosecution of police officers and how sometimes the prosecution can be attacked in certain ways. I myself have prosecuted police officers, so I understand that. I did have a question about your victim services, since you discussed that today, particularly with respect to AAPI victims. There have been some high-profile cases reported in the media wherein victims have alleged that your office has not respected their rights under Marsy's Law, and a number of them having to retain counsel to enforce their rights, their state constitutional rights under Marsy's Law. And in the extreme case, one of them filing a lawsuit against you in your office. Can you comment on why it's been so difficult for AAPI victims with cases under your administration to get information on their cases, like not knowing that their cases have been sent to diversion until months after the fact?
Thank you, Member Tung. And I remember discussing with you, I think in 2019, the cases that you handled involving police officer defendants. If my memory serves, none of them involved use of force or on duty use of force, but I appreciate the shared experience. And it's great to have a lawyer and a prosecutor who understands the nuances of the limits of the power that district attorneys have vis-a-vis other actors in the courtroom, like judges.
Right.
So
one of them did. One of them did. It was a sheriff's deputy on duty, but
yeah,
not the historic SFPD.
Right. So to your question about AAPI victims, I think one of the things we've seen as a country, not just in San Francisco, where we're proud of being the city in the 48 United States with the largest Chinese American population, but across the country, we've seen an increase in hate speech and hate crimes. I think we all know that outgoing President Donald Trump drove much of that change. He blamed China, he called it the China virus. He said all kinds of horrible, racist, dishonest things to scapegoat our Asian American community for the challenges the country was facing. That led to and emboldened people to come out and speak hatefully and treat victims of hate speech and in some instances hate crimes in ways that are absolutely unacceptable and sometimes criminal. When it comes to how we responded to those incidences and that rise in anti-Asian sentiment, I am really proud of the work we've done in my office. One of the challenges to your question, Member Tung, was that when I took over back in January of 2020, we had a single victim advocate who spoke Chinese, who spoke Cantonese, just one, to serve the entire Chinese-speaking community of San Francisco. It's unthinkable. It's outrageous. And the notion that the office was able to fully comply with Marsy's Law before I took over with a single Chinese-speaking victim advocate is preposterous. It never happened, particularly when we talk about victims of property crime. And I just want to make a point here about Marsy's Law and how it works, because Marsy's Law, which is the Victims' Bill of Rights, it's found in Article 1, Section 28, subparagraph B of the California Constitution, does not distinguish between the rights afforded a victim of a violent crime and the victims of a nonviolent crime. All victims have these rights. And yet, until my leadership fighting, despite not getting my requests in any of my budgets from the mayor when it comes to victim services expansion, fighting with the Board of Supervisors to get a add back so that I could hire 10 new victim advocates, we never, ever, until a few months ago, had any property crime victim advocates in the office. So the reality is, and this is tragic, Marsy's Law creates rights without remedies. It creates rights that are violated every day up and down the state of California. Now, we've taken historic efforts to make sure that we're not violating victims' rights. And in the particular cases that have been in the press, the irony is we have well-documented, extensive communication with those victims in their native language, in the language that they speak. In one case, after numerous well-documented conversations with the victim, informing him that the court was considering diversion and that we wanted to be able to express his views at the hearing. He expressed his views in Chinese to a Chinese-speaking fluent advocate. That was conveyed to the court. The court made the decision to accept the case in diversion. And a family member of that victim then decided that they were unhappy with the path the case had taken, and went to the press. The record is clear. The communication is in writing and detailed notes in real time. In the case resulting in a lawsuit, and I want to be very clear about this, that lawsuit will be dismissed. It is frivolous, it is dishonest, it fails to state claims upon which any relief can be granted, and it blatantly distorts and misstates the facts. That lawsuit may be well-intentioned, and I certainly share the passion and the commitment for expanding victim services and access for non-English speakers, particularly the AAPI community that is such a critical part of our culture and history in San Francisco. But that lawsuit is dishonest, it's disingenuous, and it will be dismissed. We have done more than any district attorney's office in the history of this city to expand services and access for our AAPI community. I want to give you a couple examples. We went from 1 victim advocate that speaks Chinese to 5. We created a policy that allows all of our staff to take language classes at City College during work hours if it can be accommodated in their schedule. So we increase language access. We created a policy first in the state requiring our advocates to request court certified interpreters to accompany victims and witnesses, not only when they're testifying, but when they're observing what's happening in a case that impacts them and their life. We nearly doubled the number of victim advocates overall. We hired in the last 6 months 10 new advocates, including clinical social workers, including 8 bilingual staff members. We launched, actually the day before the lawsuit you referenced, we launched a AAPI Elder Abuse Steering Committee to make sure that we're getting input and feedback from the community leaders that are impacted and that see the challenges on the ground. We announced that, just days before the lawsuit was filed, a language access policy requiring interpreters, as I mentioned. And we now have 5 victim advocates who speak Cantonese. That's a 500% increase from where I started. It's not enough, to be clear. And if the mayor or the board of supervisors allow me to hire more victim advocates, you have my word that we will prioritize hiring folks who are bilingual, multilingual, because I am committed to serving victims in ways that are culturally competent, linguistically accessible, and that meet the needs of every single member of our diverse communities. Thank you for the question, Member Tong.
Thank you, DA Budin. And Moises, are we at time now?
Yes, we just wrapped up.
We are at time, so Treasurer Morales, I'm afraid we cannot take your question, and you had a chance to ask before. So that does conclude our process for the interviews, and we appreciate both sides coming out on a Saturday to do this. And I want to reiterate that this process, today's interviews are basically interviews and discussion to hear out both sides, with the ballot measure going to the June 7th, 2022 ballot regarding the recall of the San Francisco DA Chesa Boudin. And what's coming up on Wednesday, and this is in the agenda, is an endorsement process that goes to the full members. If you want to find the detail, this is in our policies and procedures for the SFDCCC in Article 7, and that's in Section 6 around what the Issues Committee does. Now, keep in mind too, as Member Tung alluded to, there is a separate process around the Bylaws Committee that is looking to put language in that would specifically apply to recalls and how the SFDCCC would act on that. And so we're trying to thread a fine needle here in terms of keeping to our current policies and procedures and bylaws, but also being cognizant that we have these changes coming up, and these are also agendized. So we will take on all of this at our Wednesday, February 23rd meeting. Thanks again for taking the time. I will hand it back to DCCC Chair Mahogany. We will not have any new business, but we have really, heard a lot of comment and heard both sides speak. So thank you very much for taking that time.
Well, I just thank you, Chair Lovett. I appreciate you holding this committee, scheduling this, and also working with the endorsements committee, members Ibanez and members Berry, to really make sure that we held space for this important conversation. I would just like to say that, yes, for those of you who are watching, public comment, you may speak to this at public comment on this coming Wednesday's meeting. I won't go over what Chair Levitt has already said, but I do look forward to seeing you all on Wednesday, and we will have a chance to discuss this further then. So with that, I'll give you back the rest of your weekends. Happy, hopefully we will see some of you at the Lunar New Year parade that is happening later today. And Happy New Year, everyone. Take care.